This week marks a very big milestone for AMC because its massive hit, The Walking Dead, comes to a series finale after 11 seasons this weekend on November 20th. But that's not the only news about the show. The show was hit with a brand new lawsuit by Robert Kirkman, who is the creator of The Walking Dead, as well as very famous producer Gale Ann Hurd, along with a few other EPs. The headline from Deadline reads, Walking Dead creator Robert Kirkman, Gale Ann Hurd, and other EPs hit AMC with $200 million profit suit. Channel slams it as crass money grab. The other EPs that are also part of the lawsuit include David Albert, Charles E. Glee, and the former The Walking Dead showrunner, Glenn Mazzara. So what people might not realize is this show, The Walking Dead, is AMC's first true show that it has created and produced itself, right? In the past, it had two also very famous shows in the form of Mad Men and Breaking Bad. But those two shows were produced by other companies and aired or distributed on AMC. The Walking Dead is the first show that AMC has produced and distributed. And this show has made AMC billions of dollars. And it has been besieged by lawsuits along the way. There have been two major lawsuits that were filed against AMC in connection with The Walking Dead. So the first lawsuit that AMC has been embroiled in for over a decade is with Frank Darabont and CAA. Frank Darabont was the original showrunner of The Walking Dead for the first season as well as the first half of the second season. And last year, Darabont and CAA entered into a settlement with AMC in the amount of $200 million. Now, interestingly, this amount was disclosed to the SEC. I don't know if this was because AMC was counting this as a loss against the company, because normally settlement amounts are never disclosed for this exact reason. Now, Kirkman and Hurd are claiming that because Darabont and CAA received a settlement of $200 million for a buyout of all of their rights in connection with their back end and their profit participation, that they also should be entitled to not only $200 million, their complaint actually states that they are entitled to an excess of $200 million because there are several of them and their back end points actually exceed what Darabont had in his agreement. So the second lawsuit that AMC has been contending with is the exact same parties that filed this new lawsuit. And through the years, it has been basically had its legs cut off by the judge on that lawsuit because he had dismissed a lot of the different claims from that original lawsuit that Kirkman and Hurd filed. I think the only thing that's left is some accounting claims. But this new complaint is based off of Darabont's settlement, saying that, well, because Darabont received the settlement, then they should receive a very similar settlement. And I tend to agree with that. Courts like to use precedent, and I know this is a settlement and it's not a judgment, right, that a judge or jury made, but judges and juries will look at that. Now, the complaint, which is 19 pages, which I looked at, but I haven't had a chance to do a thorough breakdown of, it's 19 pages. It asks for a jury trial, which is very important, as we saw in the Johnny Depp and Amber Heard trial. Juries tend to like to protect the common man, right? Like if we use David and Goliath, they really like to protect the Davids of the world. So if you have a case like this where you have the producers, the EPs on a show suing a big network like AMC, which has made billions of dollars on the show with the claim, so this is their claim, right? Even though AMC exploited plaintiffs' ideas and services to make billions from the Walking Dead franchise, AMC issued an MAGR definition that in its original form would not have paid out a single dollar in profit participation to plaintiffs. This is from the filing in LA Superior Court focusing on modified adjusted gross receipts and other alleged sleight of hand by AMC. Unsurprisingly, AMC's MAGR definition has spurred a storm of disputes with the creative talent on The Walking Dead that ultimately resulted in litigation. So let me know if you want me to do a full breakdown of the complaint. I can do that. It's 19 pages, but with all of the exhibits, it's actually closer to 150 pages because the exhibits attach all of the EP's producing agreements. So to just focus on the Deadline article today, the article goes on to say that the trial that Kirkman and Hurd, their initial claim, is set to go to trial in February of 2023. And those are based on the accounting claims that were not dismissed by the first judge. Now, Darabont, who, came to fame as the director of Shawshank Redemption, filed their lawsuit first in 2013, almost 10 years ago. And they last year, July of 2021, had their rights bought out. Darabont and CAA saw almost all of their rights bought out for a cash payment of $200 million, which is the settlement payment, to the plaintiffs in future revenue sharing related to certain future streaming exhibitions of The Walking Dead and Fear of the Walking Dead. The agreement document of July 16th, 2021 stated. So I wanted to break this down because this is something that is a little complicated. So what Darabont and CAA did was they allowed their subsequent production rights to be bought out. All of the revenues and profit sharing attached to the subsequent productions bought out, right? So subsequent productions is something that I have to negotiate in my agreements with producers. Let's say this series, right? The Walking Dead, when they were first making the show, if it becomes a success and there are sequels or spin-offs or podcasts or video games or movies made from it, then you will share in that success, right? Either one, you'll get a first opportunity, right, to actually provide the same services. And two, you'll actually get to a profit sharing of those projects. And Darabont basically allowed himself to be bought out. So that means any spin-offs, anything that gets created in the future in connection with The Walking Dead, he will not get any money in connection with that. And so that's why it's a huge amount. It's $200 million. It's future revenue sharing. And this is something that happens a lot in the streaming world. So Netflix, when they go to an actor, and we'll use Ryan Reynolds as an example because he's kind of their darling right now, right? Then when they go to Ryan Reynolds, they say, we're going to offer you, I don't know, I'm making this up, $20 million to star in this movie. And this will include a complete buyout of your back end that you would have made had this movie gone into the box office, right? Gone into the theaters. And a lot of actors like that because there's always a gamble. Because if a movie doesn't do well in the box office, in the theaters, they make no back end. But when they go to a streamer like Netflix and Netflix gives them a buyout, they love that concept. So that's kind of another way buyout is used in Hollywood. Oh my God, just talking about back end, I could make like 10 videos on it. But back end and profit participation is very, very complicated. That's why I think they will probably settle this case if I was a betting woman. Because if you put this in front of a jury and they hear this $200 million amount, they could give even more. They could award the plaintiffs $500 million or $1 billion. I don't know. You do not want to put a case like this with big amounts and these producers who are pitting themselves against a big network like AMC. Like, you do not want to go to trial in that way. So Sheldon Eisenberg is the plaintiff's attorney, and he tells Deadline that on the one hand, AMC tells them they are entitled to nothing based on erroneous pretrial rulings which are subject to appeal, while AMC paid $200 million to Frank Darabont and CAA to avoid a New York jury's review of the exact same contingent compensation definition. Instead of giving plaintiffs the benefit of the Darabont settlement as required by the express terms of their contracts, AMC's creative activity these days seems limited to figuring out new ways to mistreat the talent that is responsible for its now past success. They make a good point. Darabont and all of these other producers have the exact same definition. So if AMC felt like it couldn't win that litigation if it went to trial and they try to break down its MAGR definition, it shouldn't go to trial now. So that's all for today. I wanted to keep it short as the show has its series finale. I think this will be an ongoing story, just like my Alec Baldwin video that I just did. If you didn't catch that, please catch it here. You know, I hate to ask, but I am seeing from my Alec Baldwin video that it makes a difference. So I'm going to ask if this video was of value to you, if you learned something, if you want to be notified when my new videos come out, please subscribe because it really does support my channel. It feeds the algorithm so that YouTube knows that I make valuable content that people will watch. So please subscribe, turn on the notification bell, please like and comment. So thank you so much. This is Tyler, the Hollywood attorney. I hope you enjoyed it. I hope you are learning something. I love this so much. Remember, you're one thought away from joy. I'll see you guys next time. Bye.